state of Ohio, and it's on report. Please be seated.
Good morning. Welcome to Lawrence County Municipal Court. Today is May 5th, and we have a few reviews to do first. Those folks will be called. This is a review to see if they've complied with court orders. And then we'll start. We have several arraignments to do, which are new cases and old cases where there was a warrant issued. So if you're here for that, you'll be called with the arraignments. Call the reviews, please.
State of Ohio versus Shandy Cooper, Chesty Fugate, Charles Brown, and Mark Oden.
Anybody for review?
Your name was called. Come forward. Mark Oden.
Yes, sir.
Okay, I think you just have some funds left.
Yes, sir. I have brought some money with me today.
How much are you paying?
I'm paid 60 today. I can pay more Friday.
All right. Put you down for 60, or to see the clerk then. Once you leave the courtroom, to the right, make your payment. I'll set your next hearing for June 16th. If you've paid it off, you don't have to come back.
Yes, sir.
June 16th, 9 a.m.
Thank you.
You're welcome. You need the case numbers on that? Got it. Shandy Cooper. Case number 21993 was called. Has finished community service but hasn't paid off the fine, so there'll be a warrant issued for failure to appear. Charles Fugate. 220798, 220664. Has done everything but 2 days of community service, so we want to check that before we issue a warrant.
I will check it, John.
And if he hasn't completed it, then go ahead and have a warrant issued. Charles Brown, 22413, called for paid fines but hasn't done any community service, so be a bench warrant for failure to appear. Okay, that finishes the reviews. Next are the arraignment hearings. So
Anybody for arraignment?
if you're here for arraignment, come in the courtroom now. When your name's called, come up to the table to your right, stand there, and I'm going to go over the charges with you. All defendants have a right to remain silent. You don't have to say anything. What you do say is all being recorded. It's all on the record, so if you admit something that's the state can use against you, it is on the record and can be used against you. You have a right to have an attorney, and you have a right to have one appointed for you if you can't afford one and you're facing a possible jail sentence. You have a right to bail, and you have a right to make the state prove any charge beyond a reasonable doubt. Those are the rights all defendants have. You waive those rights when you enter a guilty or no contest plea. You shouldn't do that. If you don't know what to do, if you want a trial, if you want to talk to a lawyer, you should enter a not guilty plea. Not guilty is always the safest plea. It preserves your rights, and no contest and guilty waives your rights. So don't enter those pleas just to get things over. That's not a good reason to enter one of those pleas. Call the first case.
State of Ohio versus Jose Umana, TRC 23460 A and B.
All right, Mr. McCown, you're representing Mr. Umana.
That's correct, Your Honor. Good morning.
Good morning. waive reading?
I do, Your Honor. Your Honor, for the record, Mr. Romano is not as a non-native English speaker, so we've had some communications issues. I think it'll be okay, at least for the preliminary aspects, but should we extend to a full-blown motion in this case or trial, we will need to have an interpreter.
Okay, and you can consider that, what, I think we're supposed to use the Supreme Court as official interpreters now.
That's correct, Your Honor. There's a rule of superintendents on it.
So and I'm happy to comply with that. At times, we've used Senor Lucas.
I understand, Your Honor.
You know very well.
Yes, Your Honor.
So it'll be your option, if you want to use Senor Lucas, or if you want us to contact the Supreme Court.
I think I would have no problem using Dr. Lucas initially, but I think for formal procedures, under that rule, unfortunately, since I'm on the Rules of Practice Committee.
Well, I kind of consider myself like a federal judge now, so I'm not as concerned with that.
I understand that, Your Honor.
But maybe you are, so I'll let you make the call.
I don't consider myself a federal judge.
Okay.
Your Honor.
I'm not really. I'm on for life, sort of.
For the record, we've also filed our notice of ALS appeal as well. I do have a motion and entry for driving privileges effective 5/13. That would be at the conclusion of the hard suspension date, if the court would consider
And
that.
Mr. Fields agreed to that?
Yes, Your Honor, he has signed off on it, if I may approach.
Yes. Okay, I'll approve your entry, and is he posted a bond? He can sign $1,000 award bond.
Okay.
Now I'll let you take the file to get your entry
Thank you, Your Honor. And
filed with the clerk's office.
2 weeks, okay, for a
Oh, yes.
free trial. I think there's going to be enough time
Let me see it.
to obtain videos.
The 19th?
Yes, Your Honor.
Okay. May the 19th will be the pre-trial.
Thank you, Your Honor.
You're welcome.
Have a great day, Your Honor.
You too.
State of Ohio versus Kimberly Short, CRB 23207.
Kimberly Short. Kimberly Short was served a summons to appear today at 9 a.m. It's after 9. She was served on April 5th. She's failed to appear, so now there'll be a warrant issued for failure to appear.
State of Ohio versus Brittany Caldwell, CRB 131153 A and B, CRB 131057.
All right, Brittany Caldwell is here. And this had been set for sentencing hearings. And it looks like you had missed a hearing May 1st. Is that correct?
Yes.
Do you have an explanation for that?
I didn't realize that it was the first. I was thinking April had 31 days in it.
Okay. All right, well, based on what I see from the last hearing, I want you to do urine screen today. So let's do that, and then I'll have you come back out. And I'll
Okay.
decide how we're going to proceed. So go to the probation office, get a urine screen done, and I'll have you recalled.
State of Ohio versus Michael Clay, CRB 201023, CRB 18796, CRB 18251.
And Michael Clay, that's you, sir? Yes. You do have a bond up. And take it, this is Andrea?
I'm-
No, I'm sorry.
No,
You're,
with Southern Hope.
Southern Hope, okay, that's where he is now. And how's that going? Can you do-
He just came yesterday, so they're gonna do his assessment when we get back today.
All right. Well, he had been at Spectrum before, and they're going out of business. So I'll approve the changeover to Southern Hope. I'll cancel the warrant, give you a new hearing date, and you can give us a report next time then. So let's set it about a month out. Let me look at the court schedule.
Your Honor, if I may, this was the gentleman that was arrested by Colgrove Police Department yesterday?
Yes.
Yeah, okay, just
And
wondering.
he came in on his own.
Yes.
So thank you for doing that. Well, he was summoned then, so not really on his own, but.
I didn't know I
He
had.
did reply to the summons, so he did come. So let's set it for June the 9th. And that's actually going to be a pretrial, and Mr. Steyer is the attorney. Mr. Steyer here today? Okay. All right, I'll set it for June the 9th for a pretrial.
Thank you.
You're welcome.
State of Ohio versus Jared Nance, TRC 220812, A and B.
Jared Nance is here, and this is for sentencing, yes. Is it Riverside? Thank you. Okay, took a screen yesterday, was
Yes, sir.
better than it had been in
Yes.
the past, I guess would be the way I'd say it. Okay, and you've been out of pocket for a while, right, since November 28th of last year.
Yeah.
Mr. Thompson was your attorney?
Yes.
I don't think, is he here?
I don't believe so.
So is there a particular reason you came to court today?
Just gotta quit running from it and get it, step up to the problems I have.
Okay. All right, well, I'll agree with that. I'll withdraw the warrant. I'll order you back in, which you've already started your treatment with Riverside. You're to conclude that. And I'll set your next hearing for June the 5th. June the 5th. And that'll be a sentencing hearing at 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
State of Ohio versus Ronald Spears, CRB 2140.
All right, Mr. Spears is here for, he had a hearing on May 1st that he missed on sentencing. Do you have an explanation for that?
I thought it was today. I had the day wrote down. I ain't had
You
it
didn't
in
make a
my,
payment on May 2nd.
I made one today,
You made one today too?
$60. I was gonna pay it off, but I can't afford it now since I added another 50 on it.
Well, I don't think it's actually added, it hasn't been added yet, the warrant fee, because it was May 1st.
Yes, they added today.
Okay, because there was a bond.
Yes.
Okay, well, you need to get these, the reason you got a warrant fee is because you got a bond, and he won't go look for you, he can't go look for you without a warrant, so I had to issue a warrant for you. I'll withdraw it now since you came in. I'll set this for June the 9th, pay it off by then, and you don't have to come back.
All right.
June 9th, 9 o'clock.
Thank you.
State of Ohio versus Kevin Wilson, CRB 23209.
Sir, are you Kevin Wilson? Yep. Mr. Wilson, it's alleged that at Rome Township on March 22nd, 2023, you knowingly caused or tried to cause physical harm to Tyler Dotson. That's an assault charge. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yep,
Do you understand your rights? How do you plead?
not guilty.
You want a lawyer appointed?
No, I think I'll get a lawyer,
How much time do you need to?
probably about a month.
I'll set it for June 2nd.
Okay,
June 2nd will be your next hearing. That's a Friday, first Friday in June. Pre-trial at 10 o'clock. I'm entering a not guilty plea for you. And protection order requested here.
Yes, Your Honor.
I'm warning you, is it a problem for you to stay away from Tyler Dodson?
no, not at all.
Doesn't live with you or next door or anything like that?
He lives a couple blocks away from me, but like this whole thing, okay, like this was self-defense.
Okay. Well, just don't go around him while it's
I will not.
So you're going to sign something that says and take that to your attorney. You'll be very familiar with it. It's called a temporary protection order. It orders you to stay away from Mr. Dodson. And he can sign a signature bond of $1,000. Okay, you need to, wait a minute, sir. You have to sign the bond. This is your promise to appear. If you don't appear as ordered, you'll have to pay $1,000 penalty plus you get a warrant. So just come to court, you won't have to post any money. Any questions, sir?
No questions.
Get a copy of the protection order, take it to your lawyer, be back June 2nd at 10 a.m. unless your lawyer says they've made arrangements for a different date.
Okay.
Okay, that's all.
State of Ohio versus Dante Pennington, CRB 23208.
Sir, you're Dante Pennington?
Yes, sir.
Pennington is alleged that at Fayette Township on March 23rd, you engaged in a pattern of conduct that caused Christina Markham to believe you would cause physical harm to her or cause her mental distress. So the charge is menacing by stalking. It's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you plead to the charge?
Not guilty, sir.
You want a lawyer appointed?
No, sir.
You're going to hire a lawyer?
Yes, sir.
How much time do you need to do that?
I already have JT Holt, sir.
All right, I'll put Mr. Holt down as your attorney. Did he give you any dates as to when he was available?
May 22nd.
Okay. May 22nd will be your next hearing date as a pretrial. 10 a.m. will be your time to be here. And so protection order requested?
Yes, Your Honor.
I'm ordering you to stay away from Christina Markham. Is that a problem?
No, sir.
Okay, you'll sign a protection order, take that to Mr. Holt. I'm going to let you sign a signature bond of $1,000. Do you understand what that means, sir?
Yes, sir.
Okay, next hearing, May 22nd, 10 a.m. Get your protection order and take it to your lawyer.
Yes, sir.
State of Ohio versus Kelly Spears, TRD 213262 A and B.
All right, and you're Kelly Spears, and you have been at Safe Harbor of Northeast Kentucky. Are you still there?
Yes.
And you're from Safe Harbor, I
Yes,
take it?
sir.
And I think what we're doing, you were trying to get your license reinstated, right?
Yes.
Making any progress on that?
I have my learners right now.
Okay, you're trying to retest?
Yes.
So you're asking for more time, I take it? When do you think you can get this done?
I can have it done by June, like,
Sometime in June, you can come back and show me you got a license?
yes.
Okay, let's make it June 9th.
Okay.
June 9th will be your next hearing. Oh, she had missed a hearing in April, so I'll cancel the warrant that had been issued. Set your next hearing June 9th. It's important that you come to these hearings, because if you got stopped between now and the last hearing, you would have been in the Hoos Scout for not appearing. So you gotta come. Even if you don't get your license, come to court, because otherwise you're gonna get a warrant.
Yes.
Okay, June the 9th for a sentencing hearing, 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Danielle Waller, CRA 08, 78 and 79, A through C.
All right, and you're Danielle Waller,
Yes.
and you've had a warrant outstanding for a long time, it looks like, on failure to appear on an assault and an obstruction charge. Correct? From 2008.
Sir, may I speak?
Who are you, ma'am?
I am her mother. She suffered a TBI back in 2020. I got the ladies up front to give you a copy of it, and she don't remember.
Yeah, so I'm totally lost right now.
She don't even know what the charge is for. She don't remember what happened. That's a symptom of a traumatic brain injury. Her
Do you have
memory
any
loss.
medical records?
Just what I gave you. I got the letter right here. I can bring, may I approach the bench?
No, you may not.
Okay.
The only thing I've got is something from Valley Health. Culver.
Yes, that's her doctor.
This doesn't tell me anything.
It says on the bottom, it says traumatic brain injury,
I don't see that.
right? History of traumatic brain injury diagnosis.
Well, let's see what you got, but maybe I don't have the same thing you do.
Another document. History of it.
Okay. Does the state take any position on this?
Well, I haven't had the opportunity to see what the
Okay.
approach, Your Honor.
Sure. It was actually filed as a felony for assault on a police officer and was reduced to a misdemeanor.
Oh, I see. This is
And it was fair.
review hearing thing.
Although it was an assault on a police officer, it was, the allegation was she kicked Jason Newman in the stomach 3 times while he was trying to write down her social security number. So, he's a pretty tough guy, and I've seen him since then. I don't think it's damaged him very much, so based on the evidence, I'm going to conclude this matter. Case is closed.
Thank you, sir.
Thank
You're
you.
welcome.
Have a good day, Your Honor.
State of Ohio versus Aaron Cron, CRA 19288.
I was at work and forgot about it. I left work early today to come here.
Okay, do you still have community service and fines and cost effect?
Yeah, I'm gonna pay some on that Wednesday, next Wednesday. I get paid then.
Well, at this point, I'm gonna lock you out. Put him in the holding cell. For missing your hearing.
State of Ohio versus Sierra Helms, TRD 222711.
Sierra Helms, is that you, ma'am?
Yes.
You had a sentencing hearing April 3rd, it's alleged you missed that.
I thought it was this month, on the 3rd, and I got it confused.
Okay, you are supposed to be working on getting your license reinstated,
I'm able to get it back the 13th of this month.
so you're asking for more time.
Yes, please.
What do you have to do to get it back?
Just go take the test.
Okay, so you're eligible to take the test after the 13th, or that's when you're taking the test?
That's when I'm able to take it, after the,
So we need to probably build in a month or more, because you're going to have to get a permit and then
yes.
take the test. Okay, let's make it June the 16th. You think you can have it done by then?
Yes.
All right, I'll cancel the warrant, set your next hearing for June 16th for a sentencing. And that'll be at 10 a.m. on June 16th.
Thank you.
You're welcome.
State of Ohio versus Abigail Hannah, CRA 23266.
Yes. Name your Abigail S. Hannah.
Yes.
Okay, they'll send you a copy of the charges.
Okay.
And it's case number 23266. It alleges that on May 3rd, 2023, in Fayette Township, you purposely deprived Michelle Hannah, who was the owner of property, being a drug, clonazepam, without her consent. So theft of drugs is a felony of the 4th degree, maximum penalty, 18 months in jail, $5,000 fine. Do you understand the charge?
Yes, I understand the charge.
Do you understand your rights?
Not necessarily.
You have a right to remain silent. Anything you say could be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Mm-hmm.
Do you have the money to hire a lawyer?
No.
Do you have a job?
No.
You have no income right now?
No, not at the moment.
Mr. Smith, I'll appoint you. OR bonds appropriate here? What's the state's position?
Your Honor, I'd like for Mr. Smith and Your Honor to be able to read the narrative.
Okay, you want to approach? Okay, I'm going to allow Mr. Smith to talk to Ms. Hannah, then we'll recall this to discuss issues of bond after that's happened.
Thank you, Judge.
You're welcome.
State of Ohio versus James Helton, CRB 23-111.
James Helton. This was set for pretrial Monday. Mr. Helton's here today. His attorney is here, Mr. Morford.
Morning.
Morning.
I just got put on night shift at work and I just got put on night shift at work and just had my days and stuff.
Judge, the reason he wasn't here Monday is because they just had his shift changed at work, and they changed it from day to night.
Yeah, I've been working from 10 p.m. to 8 in the morning and it just completely lost track of it.
How do you want to proceed, Mr. Morford?
I'd like to get back to the track we were on, Judge.
Okay, I'll cancel the warrant. Either the 22nd or the 26th of May.
Up to you, Judge, whichever is best with your docket.
Let's do the 26th. May 26th will be the next hearing for pretrial, 10 o'clock. Is that defendant's request?
Yes, we'll waive time for you, Judge.
Thank you.
You're welcome.
State of Ohio versus James Watts Jr., CRA 23-267.
Butch.
James Watts Jr.
He's in jail.
Okay, we'll pass it and we'll do him when we get to the jail.
State of Ohio recall Brittany Caldwell.
All right, well, did they tell you the results?
Yes, I relapsed about a week ago, but I'm back in a program at HHG, and I've got everything with me, like my appointment card. I was actually going to pay my fines off today, just hopefully be done with it.
Mr. Cooper, can you give me the stuff she has?
And I also had an interview at Bateman, and I'm just waiting on them to call me back for orientation.
Well, part of your original sentence was you were supposed to complete a drug treatment program, and I don't think that ever happened.
Yeah.
Did they get the results on this? You did a screen for them.
Yesterday.
They didn't give you results though?
Not yet, no.
So that doesn't say it's treatment. Do you have a medical card?
Yes,
From what state?
West Virginia.
All right, Mr. Webb, I'd like for you to talk to Ms. Caldwell.
If I pay my fines off today, can I be done with it?
No.
No.
You were supposed to complete a drug program. You never did you? And look at your, why don't you come to the bench, Mr. Webb? I would like for you to see her test results. You tested for something extremely dangerous.
My doctor told me to wait a few days with my medication to where it wouldn't interfere.
So, I want you to speak with Mr. Webb. We'll get you into, you got to complete a program. They've got a program that will fit you. I want you to do that and come back in 3 weeks.
Okay.
And I'll need a report then and a better screen,
Your Honor, is that inpatient, outpatient?
outpatient.
Okay.
We'll try, she's just got a job, so.
Okay.
We'll try it outpatient and see how that goes.
Okay.
So May 26th is going to be your next hearing,
Thank you, Your Honor.
and it'll be for sentencing. I need to look something up. Okay.
State of Ohio versus Kimberly Short, CRB 23207.
Kimberly Short? Ma'am, if you stand behind the table to your right. And you're Kimberly D. Short?
Yes.
Ms. Short, it's alleged that at Perry Township on February 22nd, 2023, you performed a tattooing procedure, body piercing, ear piercing on a person underage without obtaining consent from the minor's parent or guardian.
I received consent from the
Ma'am,
father.
Ma'am, just, I didn't ask you to speak yet. The charge is failure to obtain consent required to perform a procedure on a minor. That's a misdemeanor of the 4th degree. Maximum penalty is 30 days in jail, $250 fine. Do you understand the charge?
Yes.
You weren't here when I explained rights, so let me go over your rights with you. You have a right to remain silent. You don't have to make statements. But if you do make statements, they can be used against you if you admit something that's against your interests. You have a right to have an attorney, to have one appointed, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes.
How do you wish to plead to this charge?
Not guilty.
You want a lawyer appointed to represent you?
Yes.
Are you working?
No.
You have no income?
No.
Mr. Stratton, I'll appoint you.
Yes, Your Honor. Good morning.
No.
So it's an M4, so we have to come back pretty quickly unless there's a time waiver.
Your Honor, if I could, this is a situation in which this young lady is a victim on a case that we have currently. The alleged victim is a minor. The father of that minor is the alleged defendant in a case in which Ms. Short is the victim. He is alleged to have entered her home uninvited. He's charged with burglary. You are the same person, right?
Yes.
So I don't know, I think we're going to need a special prosecutor on this.
Okay.
I'll tell you what, let's see. It might be best to nolly this without prejudice and then approach it at a later time if we need to.
Agreed. All right.
Okay.
Great job, Mr. Stratton.
Stood up, no done.
I think you got dismissed. I don't even think you had to say anything.
No, they didn't have to say anything, Your Honor.
All right, case will be nollied, which means dismissed.
Dismissed.
With the right to refile.
With the right to refile. But you're done.
All right, thank you.
You're free to go. Okay, that finishes the arraignments that we have here at the court. We're going to proceed. We've got some hearings to do. I assume there'll be some arraignments from the jail also. We've got some hearings we're going to do by teleconference, so it looks like Mr. Bays is first in line.
State of Ohio versus Andy Bays, CRA 23-262.
Mr. Smith's case is set for preliminary hearing today.
Yes, John, I know that Mr. Bays still has a ILC violation, I believe, of Judge Ballard's courtroom, but it wasn't on Wednesday's docket. I'm not sure when he's supposed to appear in front of Judge Ballard. Because that was one thing, we set the bond Monday to see if they would go along with the same bond to get him in the treatment and everything else, but since he hasn't appeared in court, we're still on holder out of common police court, so I don't know.
Continue it for another week because obviously he's not going to be appearing till at least Wednesday of next week.
That's correct, Your Honor. I mean, there's not a whole lot we can do until, I don't know if the state agrees with that or if they.
I mean, I've already said he can have an OR bond and go to treatment. You're going to have to get the common police to agree first, and they may not.
And I don't know if I'll be appointed on that case or if it's going to be another.
Well, if it's Judge Ballard, I think he probably.
He normally does.
So come back then on the 12th.
That's fine.
All right, Mr. Bays, we're waiting on common police to lift your holder. Otherwise, we can't go forward with anything in this court until you resolve it with common police, and hopefully you'll be there Wednesday of next week.
I know he knows out here.
May 12th is the next hearing.
All right, thank you.
You're welcome.
State of Ohio versus Matthew Hudson, TRC 20-2750, A, B, C, and D, CRA 23-256.
And this is Mr. Morford's case, set for preliminary hearing and pretrials. Matthew Hudson. Yeah, the CRA case is actually a holder from West Virginia, I think, Division of Corrections and Rehabilitation, and he's got an OVI pretrial.
Well, do we know when Mr. Hudson came into custody?
I do not. But he was arraigned here on April 28th, so sometime around then that would have been, of course, he's got this holder from West Virginia, so that I think knocks out any time constraints on that. That was a week ago.
The receiving stolen property has to do with, well, let's see, a Jeep Grand Cherokee, and then there's one for the license plate as well, which occurred in 2020, on Christmas Day 2020. So I don't know what, we obviously, because he didn't appear on the 28th of December 2020, don't have any current information about what happened. Looks like he's got one from February 13th, 2019, a criminal damaging, which I don't know if he's been arraigned on that or not.
What's the case number on that?
19 CRB 188.
I do not have that file.
And then there's another one, January 29th, 2019, telecommunications harassment, 19 CRB 115, aggravated menacing, telecommunications harassment, and aggravated menacing.
Yeah, but it doesn't have any 19 case number. That's a 19 case number, 19.
188, 19,
Okay. Why don't we recall that in his case, because I don't have that file. When we get that file, bring it back out. I don't even know if he's been arraigned on this charge.
I'll call him in the meantime, Judge.
All right, for the jailer, if you could keep Mr. Hudson out, or his counsel could,
Go now.
yeah, you can go.
Thank you.
Make a phone call and talk to him before we bring him back.
Thank you, Judge.
Thank you.
State of Ohio versus Clarence Falk, CRB 04578, A and B.
All right, sir, are you Clarence G. Falk? Mr. Falk, it's alleged you missed a hearing back in 2004, November 22nd, 2004, for a conviction for obstructing official business, and a warrant got issued for you for failure to appear. That's why you're in this court. There was also a drug abuse charge. Do you admit or deny that you failed to appear back in 2004?
I will admit that I failed to appear because I didn't, honestly, I didn't even remember about it.
Okay.
It's been so long, but if I got it wrong, I would say that I should have did it.
Do you have other charges, or what? Is this the only thing you're in jail for?
Just, he just told me that I had a warrant.
How did you get picked up on this? Because at the time, you had a Georgia address.
Yeah, I was going to a job in Chesapeake, and I got pulled over and said my registration was that I got a ticket for it. And then he ran my name and told me that I had a warrant and arrested me.
Okay, how long, when was that? How long you been in the jail now?
Just this yesterday, sir.
And what kind of work are you doing in Chesapeake?
I was going to do some tile work with my buddy, just some side work, but I work, on the original recovery center in Martinsville.
Okay, so you're living in this area now?
Yes, I've been living up here since 2000.
Oh, okay, so the address that they had in Macon, Georgia was an old address at the time?
Yeah, I lived at 4616 Sunset Drive with my wife and children.
Okay. Well, you were sentenced to 2 months in jail, but it was suspended on the condition that you do some community service and pay fines and court costs, but it doesn't look like you ever did anything on this case.
Yeah, I'll be honest with you, sir. I was going through a lot of addiction things, and I ended up going to treatment in 2014, and I've been clean ever since, and whatever I need to do, I will do to make this case right. Like I said, I work at Army Recovery Center in Martinsville. I'll be clean for 9 years now.
Okay, well, congratulations on that. So I'm going to take it that you're telling me you would, rather than sit in jail for 2 months, you would rather do the community service and pay the fine for court costs?
Yes, sir.
Okay. Well, I'd rather you do that too, but getting people to do what they're ordered to do sometimes is a problem. So what I'm going to do, I'll send you your time served for contempt for not coming to your hearing before, and I'm going to give you another review hearing. So we'll go through this process again, and next time you'll just have to lay it out in jail if you don't take care of stuff. Okay?
Yes, sir.
You understand?
Yes, sir. Yes, sir.
Does it make a difference to you whether it's a Monday or Friday when you have to come back to court?
No, sir. Whatever you decide is what I'll do.
Okay, to make it easy to remember, I'll make it June 2nd. That's the first Friday in June at 9 a.m. You've got to come back to court, and what I want to see when you come back is some progress. You paid something on your fines, did some of your community service, work toward getting this resolved. Once you get it all resolved, you don't have to come to any more of these hearings. I'll set them on about a monthly basis going from here on out. And you can do community service here at the court. Actually, tomorrow you can get double credit. If you show up tomorrow at 7:30 a.m., you'll get, and this doesn't apply to him, so anybody else that's listening. Show up tomorrow for community service, you get credit for 2 days doing 1 day.
Yes, sir. And that's tomorrow at 7:30?
7:30 here at the court. It's Rome Township Cleanup Day, so we're supporting them, trying to get a lot of people there to do the work, and you probably get fed too, I think. So
Yes, sir.
it's a pretty good deal. June 2nd is your next hearing, 9 a.m. You're going to get out of jail once we process the paper and get it down to the jail.
Yes, sir.
Any questions?
No, sir. Thank you.
You're welcome.
State of Ohio versus David Newton, CRB 23-265.
Okay, sir, you're David Newton. I'm Judge Capper. You got a disorderly conduct charge from yesterday. It alleges that in Union Township, May the 4th, while you were voluntarily intoxicated in a public place, that you were intoxicated, causing inconvenience, annoyance, and alarm to other persons. That's a minor misdemeanor, maximum penalty is a $150 fine. How do you plead to this charge?
I mean, I was hot earlier that day, so that was it. I mean, I didn't think I was still under the influence of anything when he said, for him, I was still under the influence.
Okay. Well, I think they arrested you for your own protection because it says, I'm looking at the affidavit, it says you were actually at the Marathon station in Proctorville and were walking out in the street in front of traffic. So apparently they took you in, let you kind of sleep it off. This doesn't even have any jail time. So, sir, you don't need to say anything. I'm going to release you. You seem to be at yourself now, but you'll get released here shortly. So I won't impose any penalty. No fines or costs. You got arrested on a non-jailable offense. So that was enough of a penalty.
Everything, sir?
You're welcome.
No, I appreciate it, Your Honor.
Just stay out of the road. If you're going to get high, don't get in the road and get killed by getting run over by a car. It makes a bad day for you and the person driving the car.
I appreciate it.
You're welcome. Yes.
State of Ohio versus Tessa Hickman, CRA 23-250 A and B, CRB 23-251. And the state of Ohio versus Alicia Spears, CRA 23-264.
So she's got a new charge.
Judge, could we approach, or do you know?
I know there was an allegation that she was using her sister's identity.
Yes, sir.
So
Yes,
there's a
sir.
new charge relating to that. Are you aware of that?
I have not seen the new charge, but I figured that was coming. I do want to make the court aware of that OBP is willing to keep the lady.
Okay. All right. Ms. Spears has been now charged, and she had previously appeared before the court using the name of Tessa Hickman, who I understand was actually her sister. So to correct the record on Tessa Hickman, is the state willing to dismiss the charges on Tessa Hickman?
Did it get moved over already or not?
Was one of the charges bound over, or was it still here?
Well, we don't know at this point whether it actually happened or not.
I think it was still here, from what I'm looking in the file. I don't think it was bound over.
I don't know whether there was a discussion about having it bound over, or, I know that, well, we agreed that she could go to treatment.
Yes.
And believe, I don't know whether GPS was part of that or not.
It was.
So that's apparently where she was when they discovered that her name was really Alicia Spears.
Yes.
So we don't have a problem with continuing on with that plan if she will agree to waive her right to a preliminary hearing on this charge and the prior charges. We would
So you're gonna amend the prior charges?
We would, yes, to the name that we now have.
Okay.
And then if she'll do that, we wouldn't oppose her getting out and going back to treatment if the court agrees to that, obviously.
Well, I think she needs an ankle monitor.
Yes.
She had an ankle monitor before.
Yes, so we would want that to be part of it too, so if she wants to do that, otherwise we'll just have to have a preliminary hearing very soon, have her sit in the jail.
Do you wish to speak with her, or does she think she'll agree with that now? She was shaking her head.
She's shaking her head. Ms. Spears, are you agreeable with what Mr. Hill, the prosecutor, has proposed?
Yeah, I'll waive my prison and the back. I want the ankle bracelet though. I had the opportunity, if they forgot my ankle bracelet, took me all the way over there, and I stayed and waited on. I really do want to get treatment, or I, you know what I mean? I don't know, but I really do want to go to rehab and get everything done. Not gonna lie.
Okay, so case numbers 23-250, A and B, are amended to allege Alicia M. Spears as the defendant rather than, I think it was Hickman, Tessa Hickman. And then she's got the new charge of 23-264 in her name. Do you waive an arraignment on that, Mr. Morford?
Yes, Your Honor.
And we'll set it, what do you waive? She's going to go to treatment. Do you waive the time constraints then?
So waived.
So I'm going to, Ms. Spears, what I'm going to do is order that you get an ankle monitor again. And I want to make sure you understand, I probably had this talk with you before, but it's really, really serious. I want you to understand. You mentioned something about what you usually do, and I don't know what that means, but let me just say this. If I release you on an ankle monitor and you go to treatment, and you cut the ankle monitor off and leave treatment, you are going to prison for 3 years, guaranteed. And the reason I know that, I'm not the one that'll sentence you. You'll go to common police court, but I've had a few people do that, every one of them, and I've got people that were in this court that had the opportunity to go to treatment. They cut their ankle monitor off, they wound up in common pleas, and they got 3 years, and they're in prison right now.
Yeah, the ladies back there told me the same thing.
So they try to make an example out of it. And even though I tell people, I had one famously that was doing pretty good, and he decided he wanted to go to a party in Charleston, West Virginia. So he cut his ankle monitor off, went to the party. It must have been a heck of a party because he was out for about 2 weeks. He's now in prison in Ohio for 3 years. Yeah.
And you have to pay for the bracelet.
So don't be one of those stupid people that makes terrible, terrible, terrible decisions.
I will not, I promise.
So I just want you to be forewarned that that's what's going to happen if you do it.
Are they going to put the bracelet on today?
That I don't have control over.
Okay.
We will ask them to, but
We'll try.
that doesn't mean that it's going to happen today.
Okay.
And I guess we need to,
Or she going to treatment?
she was at Bethesda before.
No.
OVP, I believe.
OVP, that's right, OVP.
Yes.
And we don't have anybody from OVP here, so usually they have beds, but I don't, you know, that's a factor. If they don't have a bed, then we'll have to figure that out.
I'm going to keep my bed open, waiting to see if you would let me back out. So they should have it open. They said they're going to keep it ready for me.
Did they say they might require a new referral?
No, they just told me on my way out, and said we're going to keep your bed open. Some things they'll let you back, they let you back, they're going to come back, is what they said to me on Wednesday.
Okay.
Okay, I had initially said her hearings for May the 19th. Want to keep that date?
Please, Judge.
Is there going to be anything left here? And she's waiving today?
Oh, is she, you want to send it on down to the grand jury?
Sure. That's what our plan was from the
Okay.
beginning.
Well, they have been discussed, but I don't think we did that for some reason, because we didn't know how long it would take the grand jury. So she hadn't waived on to the grand jury before. It was set to come back here on May the 19th with her going to OVP with an ankle monitor, so.
Well, no time like the present.
Do you want to waive your preliminary hearing, Ms. Spears, so you can continue on your path uninterrupted to OVP?
Okay. The only thing on that, if something happens that OVP can't take her or the ankle monitor doesn't get placed, there's no mechanism for bringing her back up. I mean, it's going to be out of this court, it's going to be in the twilight zone. It's not in this court anymore, and it's not in common pleas.
I think we decided to keep my theft in this court, that way I wouldn't be in the twilight.
Well, that's true, that she has a misdemeanor theft that we did not send. We didn't intend to.
Yeah.
Okay, that's 23-251.
Yes, we could actually, then, Your Honor, just set it for Monday or next Friday or something.
Okay, let's check, on 23-251, rather than the 19th, I'll set it for May 12th. That way we keep track of what's happening with her. All right, then on 23-264, 23-250, you're waiving the right to a preliminary hearing.
Yes, sir.
And agreeing that the case can go to the grand jury for indictment. Do you understand that, ma'am?
Yes, sir. Yes, sir.
Okay.
Is she waiving 23-264 also?
Yes. Just put the same case number on one waiver, and she can just need to print a waiver and have it sent down to the jail. Okay, you'll have a waiver sent down for you to sign on your preliminary hearing. We'll see her back here on May the 12th for a pre-trial. I'll order whatever orders we need to get the ankle monitor replaced, and her back in OVP. We'll do that.
Thank you, Your Honor.
Good luck.
Thank you, Your Honor.
Now, the ones that you were, the theft were keeping here, right?
Yes, May 12th.
Is he willing to plead guilty? We're going to ask for it.
Going to the grand jury.
And we'll come back for a preliminary, whenever we do it quick.
Yes.
State of Ohio versus James Early, 23-268.
Surrey James Early. Can you answer out loud, please? I'm Judge Capper at the Lawrence County Municipal Court, and this is your arraignment hearing. Case number is 23-268. It alleges a theft offense that May the 1st in Fayette Township, you tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand well, let me explain your rights. You haven't heard your rights yet. You have a right to remain silent. You don't have to make statements. If you do make statements, they can be used against you. You have a right to have an attorney appointed if you can't afford one. You have a right to bail. You have a right to make the state prove this charge beyond a reasonable doubt. Do you understand those things? How do you wish to plead to this charge?
Not guilty.
Do you want a lawyer appointed?
Yes, sir.
Do you work? Do you have a job?
No, sir.
You have no income?
No, sir.
I'll appoint Attorney Tyler Smith to represent you. I'm entering a not guilty plea. Do you have any holders from other courts? Which court?
In Indiana.
Okay. Well, I haven't seen that yet. Anything from any courts here in the county?
No, sir.
I've got a Proctorville address for you, Township Road 1321.
Yes, sir.
That's the correct one?
I'm so sorry.
County Road 411.
It's 784.
Yes. Okay, I've got two different Proctorville addresses.
Yes. Sorry about that.
Okay, it does say in the affidavit he has a warrant from Steuben County, Indiana, so we need to look into that. Shouldn't be having an extradition hearing too. We'll have to deal with that warrant, sir. So in this case, I'll set a OR bond, but he's not going to get out until the Indiana matter gets addressed. So we need to look to see where that warrant is so I can arraign him on the warrant from Indiana. Come back in a week.
That's fine.
May 12th will be the next hearing for pretrial at 10 o'clock.
Is that don't have to be here yet?
No. I don't even have anything on that yet, so. We'll have you back out when I get more information about the Indiana warrant, then I'll deal with it then on the bond on that. But right now, I've given you an OR bond, but you can't get out even if you sign an OR bond because you've got this holder from Indiana.
Yes, sir.
Thank you, Your Honor.
You're welcome. That's it.
State of Ohio versus James Watts Jr., CRA 23-267.
Sir, are you James Watts Jr.?
Yes, sir.
I'm Judge Capper. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you do make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove this charge beyond a reasonable doubt. Do you understand the rights you have?
Yes, sir.
You're charged with possession of marijuana, but it's a felony. It's alleging that at Union Township, May 2nd of 2023, you not only obtained, possessed, or used a controlled substance being marijuana, and that it was in an amount exceeding 1,000 grams. So that makes it a felony of the third degree, maximum penalty 5 years in jail, $8,000 fine. Do you understand the charge?
Yes, sir.
Do you have the money to hire a lawyer?
No, I need a lawyer.
You don't have a job?
No, not that long. I've been going down to the middle of the working on the weekend. I've been little steady, so.
How much do you make there?
Around 400 or 500 a week.
Well, that's pretty good for working with it.
I buy and resell pallets there. Currently, the legal side, the legal hustle for myself and my landlord is starting storage things. I've been buying pallets of that tri-state litigation going around. It's pretty easy. Going down to the right shows on that. Trying to make a living for myself.
Okay, so, you're making 20,000 a year or more?
I just started doing it about a month ago. I'm not really sure.
Do you have any money saved?
No, I just lost my money the other day.
Mr. Morford, I'll appoint you.
You said what?
I'm appointing a lawyer for you, he's here. Mr. Morford is going to be your lawyer. What's the state's position on bond for Mr. Watts?
Well, this is a little out of the ordinary set of circumstances. I don't know whether this is indicative of a drug problem that needs interdiction by an agency. If so, then we would not be opposed to an OR bond as long as treatment's involved. And at this time, I don't know whether this is a case that would go to the grand jury or not. It may be, but we would still like to see him attend to some treatment.
Mr. Morford?
Judge, I'd really like to talk to him. I'm sure he had no problem with OR, but I don't know if he, are you agreeable to go to treatment, Mr. Watts?
Like a rehabilitative?
Yes.
Yeah, that's the deal I would like to have, if I can.
Okay, Judge, you got to talk to him on the telephone.
Okay, I'm going to let you talk with your lawyer, then I'll have you back on the screen after you've done that, so this case will be recalled.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio recalls Matthew Hudson.
This, Mr. Morford, these are your cases, and I've got those 19 case numbers, and he was never arraigned on these. All right, Mr. Hudson is back on the teleconferencing, and we pulled the old cases that he was never arraigned on. 19115A was an aggravated menacing from January 28, 2019 in Fayette Township. It was alleged that he not only caused Opal Sloan to believe it caused serious physical harm to her personal property. Then there was a B case, aggravated menacing, involving another same date and time, involving an Ann Maynard. Same possible penalty. 19188, who was never arraigned on, was a criminal damaging. From February 13, 2019, where it was alleged he caused a damage to windshield of a car that belonged to a David Ellis, second-degree misdemeanor. This happened in Fayette Township too, it's alleged. Maximum penalty for that is 90 days in jail, $750 fine. I'll go ahead and enter a not guilty pleas on those. Okay, and then he has this holder from West Virginia.
He's willing to waive extradition on that, Your Honor.
Well, we need to resolve these Ohio cases first. What's he want to do on those?
Once he got the treatment.
Well, he's got an OBI in here.
One of the things that we would need to do is consult with the alleged victims on these matters, and it is, has been some time, but we have information, I believe, to get a hold of them to make sure, because there's I believe, a criminal damaging charge, so I'd like to know about restitution on that. There's also a felony receiving stolen property charge having to do with a vehicle, so, and the way the narrative reads, it sounds like it was crashed. So I don't know what restitution might be at issue, so we need to have some time to figure all that out, and also to figure out if the felony cases may not need to go to the grand jury, just depending on what we find out. So in the meantime, we would ask for because this case has been a pending felony case since December of 2020, we would ask for a $10,000 cash surety bond. And depending on how long he's been in jail, we'll need to set a preliminary hearing fairly soon.
Well, he's got a holder on his parole violation. That's right. West Virginia.
Yeah, he was a little confused about that, Judge. He indicated that he had had his parole transferred here to Lawrence County, to Interstate Compact, and his parole officer here is James Willis, and I can speak to Mr. Willis because his office is just across the hallway or across the lobby from my office. So I'll talk with him between now and the next time we come back.
Okay, and when would you like that to be?
Judge, I know he'd like to get this resolved. I'm not sure what his date of arrest was. He couldn't tell me when he came into custody.
He was arraigned on April 28th.
We're getting pretty close.
It'd be around that.
So, I'd like to get back in as soon as you can put us here.
Well, I can put you on Monday, but it's not going to do us any good because you won't have any information by then. I think what makes sense is a week from today.
Friday.
12th. May 12th. All right, I'll set all of Mr. Hudson's cases for May 12th at 10 o'clock.
Thank you, Your Honor.
You're welcome.
I'm listening, but I'm also
State of Ohio versus Garrett Johnson, TRC 23-386 A and B.
All right, this is set for pre-trial today. Mr. Donald has entered an appearance for Mr. Johnson.
Good morning, Your Honor.
Morning.
What's his name? May we approach, Your Honor?
Yes.
Thank you. What's his name? I'm sorry. Johnson.
How are you? Good. Good. Yeah. You never know what you're going to get. It's just a first one. said, well, what if we try to do into some of that? Did some counseling or something, that's a crime. Well, and it's even being received from a lot of times they kind of sugarcoat what or the jail. Okay, come back out of my horse later. You got it, Dave. It's going to be a Monday or Friday, so it doesn't, anything in June is forgiven. How's that, June 23rd? All right, it's my understanding, we're going to continue this to June 26th, and we'll have some information provided to the court to consider then. Then it waives time constraints till then, so June 26th will be the next hearing at 10 a.m.
Thank you, Judge.
Good luck.
Yep. Was there a plea?
We don't care if we're going to do it now or later.
You want to plea now?
Yes.
Okay.
Sure.
All right, it's my understanding there's going to be a change of plea by Mr. Johnson,
That's correct, Your Honor.
and the plea is,
Guilty, Your Honor.
is that correct, Mr. Johnson?
Yes, sir.
Okay, so what I'm going to do, it's my understanding from your attorney that you're going to get some counseling and show that to the court, because just on the face of it, you're looking at jail time. So you got to convince me that you don't. I want to be convinced that you have dealt with this, and I'm never going to see you in here again or in any other court for anything like this ever again. So, ball's in your court. Otherwise, it's to the jail. And that's mandatory. It's not like, I'm not stretching to say, oh, I want to put this kid in jail. No, I really don't want to put you in jail. But the legislature writes the law. And they say if you test at a certain level, you have to go to jail. And you're in that category right now. So you're going to have to convince me to take yourself out of that category. So bring me some good evidence. June 26th, the next hearing.
Absolutely, Your Honor. Thank you very much.
You're welcome.
Yep.
Okay.
State of Ohio versus Joseph Cremines, CRB 22-658, CRB 22-655.
Mr. Smith's case?
It is, Judge.
Yes.
Do like kids treatment. Excuse me. Do like kids treatment.
Okay, it's a good report. Continue on.
I think so, Judge. He just entered the program, so that would be my recommendation.
What's your schedule, June 9th, 12th, 16th, somewhere in that range?
June 9 is out, the 12th or 16th are both good.
June 12th.
Yes.
Your Honor, if I may make a comment on this.
Sure.
First of all, we're very pleased with Mr. Cremines' advancement here in treatment. He's got family members that are rooting very hard for him to do well. And his life has a big impact on theirs, whether he knows it or not. He needs to think about himself and his family. Second of all, we've got two different victims here, and they haven't committed to any particular kind of outcome. However, his success in treatment is going to have a big bearing for us on how we want to treat these charges. So we want him to be successful.
All right, June 12th will be the next hearing.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Abigail Hannah, CRA 23266.
All right, we're recalling this. We let Mr. Smith have a conversation with Ms. Hannah, and we're ready to proceed.
We have done that, Judge. She is living in Ohio now with her parents. She is to any type of assessment the state feels is necessary. She does not have any kind of medical card or insurance. I'm assuming someone can help her get a medical card, but we understand the request by the state.
She appears to be eligible for a Medicaid card.
She does. She's unemployed, lives with her parents. Correct?
Well, I think we need dual treatment.
I believe so, based upon the complaint. I agree.
So
And I've talked to her, she's okay with dual treatment.
I need an agency that can do mental health and substance and can help this young lady get a medical card.
Ohio.
Ohio.
You never get Ohio Medicaid.
She appears to be eligible for Ohio Medicaid.
She does. She's unemployed, living with her parents.
All right. See, Mr. Webb, can get that set up. And did you say you're not available the 12th?
The June 9th, I'm not available. I'm available.
Well, I want to come back earlier.
I can do that. I can do pretty much any time in May.
Let's do May 22nd.
I can do that.
She can sign a $1,000 signature bond. Ms. Hannah, you'll need to speak with Mr. Webb, get your session set up, come back May 22nd, and give me some good reports then.
Thank you.
You're welcome.
State of Ohio versus Casey Jackson, CRB 22510 and CRB 22165 A and B.
Yes. Yes.
He's on it since last week. Yeah. No, I called him.
Okay, I think the last time we were looking for a report and it came in after court was over. I have that in the file now.
Correct, Your Honor.
With Pat, so he continued, looks like there was things he was working on.
Yes, and you've had another session by telephone
Yeah, since last week.
since last week, so he's actually had another session, so hopefully we're on the right path now.
Yeah, and I think I said it fairly quickly because we couldn't get a report. I do have the report did come in after the last session, so I'm willing to go out a month or so now, since it looks like he is participating. So what, June 2nd, June 9th, somewhere around then?
June 2nd, I'm not available June 9th, Your Honor.
All right, June 2nd will be the next hearing. $10.
Thank you, Your Honor.
You're welcome.
Your Honor, hold on, it shows we have a warrant. Hold on, Mr. Judge.
Casey Jackson. Can you do it?
He's got a CRD, she can do it. He's got a warrant.
Okay, sir, don't come back in the courtroom. You got a case that's on.
Let me go get it.
Have a seat, we'll recall once we get it out.
State of Ohio versus Jeffrey Ingram, TRD 173347, CRB 2393 A and B, TRC 230134 A, B, and C.
Hey, I've been checking to see if you were here. Running late, weren't you?
These are Mr. Stratton's cases, and
Yeah.
they're all set for pre-trial.
Just one second, Your Honor. Sorry, drug test being done. But the one you dropped from both the child endangerment, we plead out the OVI. Okay, what's the, yeah, I mean, it'll just be suspended time. Okay. Okay. Please want to plead out to the OVI and discuss the child endangerments.
Well, when were we here last time?
We talked about on 421. Maybe that's what we just talked about.
I know, why was he not here on 421?
Your Honor, at this time, we're going to plead guilty to the OVI. I understand that the state is going to dismiss the child endangerment charges.
We're not necessarily opposed to doing that. That was discussed back on April the 21st, but Mr. Ingram, I don't believe, appeared before the court that day. And I don't know when the last time he did appear. I just would like to have some sort of an explanation as to when we on the one hand, are offering some consideration, but on the other hand, you know.
I was out of town working on the day we had court, and then I came in the next Friday. He was out of town working, Your Honor. Then he appeared and got put back on the docket. So last Friday. Last Friday.
Well, it looks like he missed the hearing on the 21st.
That's one we're speaking. The prosecutor's speaking of.
Are you satisfied then, or how do you want to proceed?
We can proceed in that way, Your Honor. If he's going to plead to the OVI, then not only the other charges.
Yes, Your Honor.
And there was a urine screen. Did we get results on the urine?
We do have results, yes.
And it was positive for meth. So
Okay.
that is something that needs to be addressed.
We also have a driving under suspension and a headlight charge also plead guilty to those.
It was something on the rear, apparently.
Yeah,
Rear
rear light, I'm sorry. I just have lights written down.
And he's pleading guilty to all those charges?
Yeah, and I understand that child endangerments will be dismissed.
All right, Mr. Ingram, do you agree with your attorney?
Yes, sir.
Is there anything you want to tell me before I sentence you?
Just, I mean, I had been with my mom for like 5.5 hours before this with my fiance. So, like, as far as being intoxicated when I was driving, that, I mean, I get it was my system because I don't know what the law is or not. But I wasn't being neat, but I don't know what you'd call it.
Well, Your Honor, he was over the legal limit. I think what he's trying to say, he was over the limit he was positive for meth, but he wasn't to the point where he was impaired. He wasn't extremely impaired to the point where he was driving all over the road or
And that's not the standard for getting a conviction. You just have to be impaired.
Right. Yeah,
Now, what you need to understand, if you enter a guilty plea, that's a complete legal admission that you
Yes.
were impaired.
Yes,
You
I
understand
understand that. Yes, yes.
And you want to continue with that
Yes.
guilty plea? All right. Okay, on the OBI, I'll impose a $500 fine, first offense. Order him to pay the court costs, 6-month license suspension, which will start today. Uh, 20 days in jail suspended, 5 days of community service, 2 years of probation, level 4. Do you have a medical card?
No.
How do you pay for medical services?
I don't get medical services.
Are you employed?
Yeah.
What do you do?
I work at a construction company, right remodeling.
Okay, so you're getting paid by the hour?
Yes.
Okay, well, I think to decide how I'm going to proceed further on sentencing, I wanted to do a urine screen today. So
Yes, Your Honor.
Let's do that, and then I'll have him back, and I'll decide, finish up the rest of the sentencing.
All right.
The question in my mind is whether to order you for additional treatment, and I'm going to base that on what I see in your urine screen.
Yes, Your Honor.
I don't care to do outpatient treatment.
Okay. He's going to want to know.
Go to the probation office. and
Go to
get
the
your
probation, right there. It's over there. I'm going to touch you.
State of Ohio recalls James Watts Jr. into jail, CRA 23267.
This is Mr. Morford's case. You had a chance to talk with Mr. Watts,
I have, Your Honor.
and how do you wish to proceed?
He's agreeable to the bond suggested by Mr. Hill, OR plus treatment.
And do you have a medical card?
Judge, unfortunately, he does not. He moved here, I think he said a month ago, from Huntington.
Do you have a West Virginia medical card? Okay. All right, so we've got Ohio resident, no formal income, it doesn't sound like. Riverside? Okay, I'm going to refer you to Riverside on an OR bond. State's not committing to keeping it here, is what I'm saying. We're going to do a test run and see how things go, then you'll make a decision down the road.
That is correct, Your Honor.
And
Understood.
if it's agreeable with that, and agree to waive time constraints on the preliminary hearing.
Understood, and we'd agree to waive time.
So the best thing you can do, if you want, you have a chance to keep your case here, not go to the grand jury, not get an indictment. The state's not guaranteeing that. They may still do that regardless of what you do. But I'll say this, I think I'm fair grounds to say this. If you don't do the treatment, or if you do it haphazardly, or get bad reports, then they're going to be more likely to take you to the grand jury and indict you, and you're going to go that full route. The best chance you have of not getting an indictment, not getting a felony pursued against you, is to do really well in treatment. You understand that? And that's up to you. So I'm referring you to Riverside. Do you want, give me your, do you have a cell phone number where you can be reached?
I have, Judge.
Okay.
304-563-8840.
Did you get that, Mr. Williams? So someone from Riverside is going to call you and set up a time for you to come in, get an assessment, get you started on treatment. If you don't do it, I'll just say it this way, if you don't do it, you almost guarantee your case is going to go to the grand jury and you are going to get an indictment and a felony pursued against you. You understand that?
Your Honor, I have somebody calling the jail right now.
Okay, somebody's calling the jail right now as we speak.
Judge, there might be a slight time period to be able to reach him by cell phone when he's released, because I think it was seized by the Chesapeake Police Department.
Okay, well, they're calling the jail to talk to him at the jail, is my understanding.
Yes.
So, when to come back?
So, Your Honor, are we anticipating that he would be released to the counseling agency out of jail, or is he just going to be on his own to hook up with them after?
I wasn't requiring inpatient at this point unless that's what you He hasn't been assessed yet. Or you only want him to go to the inpatient, or?
I don't know the extent of his addiction issues, and it's marijuana, so, you know, our society's, I guess, deemed it to be harmless now or whatever. The quantity, of course, makes this serious, but I don't know to what, if that points to other addiction issues. If we had a drug screen and we saw what was in his urine, that might.
One of the problems of doing these teleconferences, it's hard to get a urine screen.
So that might give us a clue. At this point, I mean, what we'll do is if he doesn't get into the whatever counseling is recommended, we'll just take it to the grand jury and he'll risk going to prison. So he probably would prefer not to